What should I do when I find out about the outcome of my 51B investigation in Massachusetts? There are 4 different outcomes in Massachusetts. In each and every one, you should take steps afterwards upon learning of such result. When your case has been unsupported, you should absolutely send for the records and the documents. And you're going to say, why is that? At some later time, you may apply for a job, or there may be future investigations against you. You want to make sure you have those documents to illustrate and indicate that the case was unsupported, so that when you go for that job or DCF re-enters your life, you can say this was unsupported before. It's already been investigated. Or you can have some other criteria that may come up in the future. The second type is a substantiated concern. And that's where DCF's unsure of whether it should or should not be supported, but they want to do an assessment after the fact. And what you're going to want to do is you're going to want to have a lawyer present to come between you and DCF during this assessment, so that things are not taken out of context, things are not misstated, misread, or mistranscribed, and that your rights are protected. But you also want to appeal this substantiated concern to what is called a grievance. The third type of support decision may or may not have an assessment, but regardless of whether they have an assessment or not, you're going to want to appeal that within 30 days to what is called the Department of Children and Families Fair Hearing Unit. With that said, you always want to sustain and support your appeal rights. One for a grievance on a substantiated concern. If it's a supported decision, you must file for a fair hearing within 30 days of receipt of the letter that states that you have the right to such an appeal.